All right, good afternoon. Welcome to our webinar on the status of evictions in California and AB 832. I'm Ashley Peterson. I'm a member of the Real Property Law Section Executive Committee. For those who are not members of our section, we'd encourage you to join. You don't have to be a lawyer to be a member of our section, but membership gives you access to all our incredible webinars for CLE credit, our on-demand library, the quarterly publication of the Real Property Law Journal, our monthly e-news, our monthly podcast, What's Up With Us on hot topics in real estate, and super fun networking events that are in person that are coming back this fall. So membership's only $99. If you haven't joined, it's a steal. I'll post the link in the chat box for those who are interested. All right, with that, we are thrilled to have our esteemed speakers with us today, and who are all located in San Diego County and specialize in landlord-tenant law and evictions. They've all generously volunteered their time to do this free seminar today. We have over 260 some odd people registered, so we'll probably have a lot of questions to get through. So we hope you keep your questions. You can type your questions in the chat box during the presentation, and we'll try to get to as many as we can at the end. So our speakers we have today, we have Rachael Callahan with San Diego Evictions. We have Lawrence Mudgett with Safer Law, Gilberto Vera with Legal Aid Society, and Michael Olinik with the Law Office of Michael Olinik. And without further ado, I'll let you guys get started. Thank you.
Thank you, Ashley, for the introduction. My name is Gil Vera from Legal Aid Society San Diego. I'm going to start off my presentation just quickly reminding people about what has been extended through AB 832, mainly what protections were extended from SB 91. We're not going to spend too much time covering the protections that were already in place in SB 91, just specifically the dates, because we want to focus on not just the extension of dates, but the changes to the emergency rental assistance program, as well as what is the COVID recovery period as defined by the statute. And so I'll start talking about focusing on the changes to the emergency rental assistance program. Okay, first, just a quick disclaimer. The law in this area is rapidly changing. This is intended to be a presentation to provide general information regarding legal rights in housing in California. This is not meant to be legal advice. And as always, consult your attorney before making any decision, and this is not legal advice. And I'm sure you'll get the same caveat from my fellow presenters. So just a quick recap of how we kind of got to where we are now. Originally, the bulk of the protections passed by the COVID-19 Tenant Rental Relief Act were in place via AB 3088, signed into law August 31st of 2020. These protections were extended and expanded via SB 91, which was signed into law on January 29th, 2021. And the most recent iteration is AB 832, which was signed into law on June 28th and extended the protections of SB 91. The main extensions of the protections were that for eligible tenants who are not able to pay rent because of COVID-related financial distress, their ability to turn in a COVID-related financial declaration in lieu of paying rent, those protections were extended from June 30th to September 30th, 2021, so 3 months. Additionally, extended an additional 3 months were the just cause eviction protections for all residential tenants within the state of California. And also extended were penalties regarding for increased damages for illegal lockout of tenants, shut off of utilities, or engaging in other extreme or harassing behavior on the part of the landlord. Also extended were what's known as masking protections, which is what prevents a case from being part of the public record. Unlawful detainers, when filed, are not accessible like many other civil cases, and generally are not accessible unless there's a judgment entered against the defendant. Currently, if the masking protections have been extended to all non-payment cases relating to COVID-related financial distress will be masked, meaning not accessible to the public indefinitely. So like I mentioned, I'll be focusing on the rental assistance portion. SB 91 originally created the Emergency Rental Assistance Fund within our state. AB 832 expanded and has now grown to be about $5.2 billion of rental assistance available within our state and distributed to counties within our state, depending on census data from 2019. And the Rental Assistance Fund prioritizes the following households in this order. For households that have less than 50% of the area median income, communities disproportionately impacted by COVID-19, and then the last priority is remaining households with less than 80% median income. The Rental Assistance Fund will be given a priority to be used to paid rent. If available, funds can also be used for prospective rent payments, which is future rent payments, utilities, and other expenses related to housing incurred directly or indirectly by COVID-19. From what we've been seeing, we've actually had the opposite issue of these funds not being able to spend down as required by certain law, by the certain federal statutes that created these funds. If not, some of these funds have to be returned to the federal government. So I haven't seen any of our 3 local emergency rental assistance programs, which are the City of San Diego, the City of Chula Vista, and the county. So if you live within the City of Chula Vista or City of San Diego, you have to apply to those specific funds. Anywhere else you live in the county, you apply directly to the county. I haven't seen them begin to prioritize the use of these funds currently because there's so much. There's only about half of these funds encumbered so far. So they want to be able to spend those down, and I haven't seen them begin prioritizing any of these, although the statute does create priorities. So I assume that if those funds start to get spent down, that the rental programs might start creating these priorities. The new changes are that the rental assistance now covers 100% of COVID-related rental debt incurred after April 1st, 2020 for up to 18 months. So this rental assistance, it could be, and it's 18 months, not guaranteed, but every household has a limit that they can't apply for more than 18 months worth of emergency rental assistance. And the households can continue to apply if they haven't met that 18-month threshold, as long as there are funds available. So there's also not a guarantee that you'll get 18 months, just a cap. Also, a new change in the law is local agencies administering these programs, which I mentioned are the City of San Diego, Chula Vista, and the county, are in the process of creating these new application portals because AB 832 mandates that these programs must have a way for courts, the landlords, and tenants to be able to access the application information so that they can get real-time information as to the address, the names of the landlord, the tenants, the amount of rent that was applied for, and what is the current pending status of that application. Previously the landlord and tenants could do that, but the court didn't have an access to be able to check what a current status of an application is. It's not included in the slide, but from speaking with the 3 different local programs, they're currently working on creating this new portal, and it's currently not live yet. And this is something that hasn't necessarily changed. It was also part of SB 91, but there are affirmative statements that a landlord must make before a judgment can be entered in a unlawful detainer, and those requirements have been the Judicial Council has created UD Form 120 so that the landlord can fill out and make these affirmative statements, and they all kind of relate to emergency rental assistance, that the landlord has not received any rental assistance or financial compensation for the amount demanded in the complaint, and that they have not received any rental assistance or financial compensation of any other source, even after the service of the notice that's the underlying reason for the complaint. Additionally, they have to make affirmative statements that the landlord doesn't have any pending rental applications for rental assistance for the amount demanded in the complaint, whether before the unlawful detainer was filed or after the notice expired. So essentially, this does not necessarily mean that if the landlord has received it or has a pending application that the unlawful detainer for non-payment will be dismissed, especially if it's pending, just that maybe the case cannot progress. If rental assistance has been already paid for the amount demanded, then arguably that case should be dismissed. Although, it could vary on, how much rent was demanded and what exactly is the underlying cause of the UD. So there's also been changes to whether a landlord has to participate in the rental assistance program. Under SB 91, in order for the tenant to receive the maximum allowed rental assistance, which at that point was 80% of the rent demanded during a time period, it required the landlord to participate. If not, the tenant would only get 25% of the rent of the COVID-related rental debt. AB 832 has now changed that and does not require that the landlord participate in for the tenant to receive 100% of the COVID-related rental debt. There's still a preference that landlords participate, and so applications are going to be geared that way. And if the landlord refuses to participate, then the tenant would get 100% of the rental debt paid to them directly by the local program administering the fund. And then the tenant, after receiving the funds, has 15 business days to provide the full amount of the COVID rental debt to the landlord. So essentially, the tenant gets the money, but it can only be used to pay the rent for which the money was given to as part of the rental application. The tenant can't spend it on anything else. And when the tenant receives the funds, they must sign a statement under penalty of perjury that they're only going to be using these funds to pay back the landlord for the COVID-related rental debt. One thing that I was able to clarify through, although it's not, it doesn't forbid it as part of the statute, if the tenant has COVID-related rental debt that they owed to a third party, either because they borrowed money to pay the landlord so that they were able to stay current with their rent, or maybe they used credit cards, it's technically COVID-related rental debt owed to a third party. However, under the current version of the ERAP program we have, those funds, the emergency rental assistance funds, cannot be used to pay a third party for COVID-related rental debt. Also, one of the major changes under the emergency rental assistance program is before, under SB 91, if you had COVID-related rental debt and you moved, you are no longer eligible to have to access these funds to pay your former landlord for the COVID-related rental debt that was incurred. Now tenants are eligible to pay 100% of their COVID-related rental debt, even after they've moved out to their landlord. Again, it doesn't require the landlord to participate, the former landlord to participate in that application, but it's preferred, and applications with landlord participation will be prioritized over those applications where where the landlord is not participating. So if you have clients out there, whether they're landlords and tenants, and there's COVID-related rental debt, and there's no longer a tenancy, I would encourage those parties to communicate in order to facilitate to get these funds back, because especially if possession is no longer at issue, there should be no reason why the former landlord and former tenant can't come together to apply and get relief for the tenant of the COVID-related rental debt, but also to pay the landlord for the debt that's owed to them. So one of the new things is that under the prior program, landlords who participated would have to accept 80% of the COVID-related rental debt between April 1st, 2020 and March 30, 2021, and would have to agree to forgive 20% of that debt. And it was a requirement to participate in the program. Now under AB 832, landlords and tenants are eligible for 100%. So landlords who previously participated and forgave 20 will be retroactively paid by the local agency for that 20% they forgave. Additionally, under SB 91, for emergency rental assistance, it would only cover 25% of the rent owed for April, May, and June 2021. And so if a landlord participated and received only 25% of that, of the rent owed during that period, the local agencies will automatically pay the landlord 75% rent for those time periods. And these are all applications that have already been approved and processed. And so the local agencies are going to be sending these funds automatically without any further documentation or signatures needed by the landlord or tenant, because these are for time periods where eligibility has already been confirmed, and all the documents signed. So they should be occurring automatically. Right? And I know that we've had some of our clients, their landlords confirm they've already received these retroactive payments to bring them up to 100. And the way these payments will work is they will be automatically issued to the party who received the funds under the ERAP 1 program. So if the landlord participated, they'll get the funds directly. If the landlord refused to participate and the tenant only received the 25%, then the tenant's going to be receiving that remaining 75% to bring it up to 100. And they would also have that requirement of delivering those funds to the landlord within 15 business days. And from what I've been hearing, like I mentioned, I've had clients with the county, city of San Diego, and Chula Vista who've confirmed, not all of them, but at least some of them confirmed that these payments these automatic retroactive payments have already been made. I also have, these are the links to the 3 different rental assistance programs I've been mentioning that are within our county. These are the only 3 that exist within our county limits. And I will now hand it off to Lawrence.
All right, thank you, Gil. I appreciate it. I certainly learned a lot. I know I get questions all the time from landlords and tenants about that program. Let me put all right, so I'm assuming everyone can see the slides. So my name's Lawrence Mudgett. My office is Safer Law, and I'm going to focus on the portion of AB 832 that they call the COVID-19 Rental Housing Recovery Act. Okay, so yes, nothing herein is legal advice. These are my opinions. All of this changes. It's changed many times over the last year and a half. We've been litigating cases on, and I should say I represent both landlords and tenants. So I'm pretty familiar with how things work on both sides of the aisle, and there's certainly been lots of changes. So if you're looking at these slides later or watching this later, just understand it may not be the most up-to-date information. I thought Gil did a pretty good job covering the history, but I kind of started here with several of the moratoriums that we've seen since this kind of went into effect around March. They started rolling this stuff out, and I bolded the state ones because really that's what the focus of today's presentation is on. But also note, in addition to the residential stuff, there's also been commercial restrictions, of course, the court closures. And there were long periods of time here in San Diego where the sheriffs weren't doing lockouts. And just as a general understanding, if you do evictions or you're familiar, not so much, these moratoriums create layers of rules. So you may have a property that is subject to a state rule like we're talking about today, and then certainly a local rule like what we're dealing with in San Diego County with Ordinance 10724. And then they're pretty well phased out, but there's still some federal rules that could apply. So I underline, the local knowledge is really the key to all of this. That attorney who knows what they're doing in the locality is familiar with the system and the way things are done, because things can vary county to county. Even cities within the county are doing things differently. So you really, really have to have that local knowledge if you're going to be considering doing eviction work during COVID. So just the state history in a little bit more detail. I thought Gil hit it really well. I'll kind of go through this fast. AB 1482, now I always start with that one. It wasn't a COVID rule, but it went into effect January 2020. And it gives us Civil Code 1946-2, which is our just cause statute, and 1947-12, which is the rent cap. All of the ensuing COVID rules, and certainly like the local restrictions we're dealing with now, rely heavily on this code. So if you're, that's something you should be very familiar with, and how these different statutes pertaining to COVID rights interplay with it and restrict a landlord's property rights, essentially. So after the executive orders, we had Judicial Council Emergency Rule 1. As Gil said, AB 3088. That was the general framework that we're still under today. It's been expanded, it's been modified, it's been continued, but that concept of the tenants pay 25% of the rent, they give you the hardship declaration, you can't sue them, the cases stay masked, you can't send them to collections, all that stuff came back last September and was set to expire January 31. Then, as Gil said, AB 3088 came in, and that was set to expire June 30th. Excuse me, SB 91 came in. That was what was set to expire June 30th. And that was really billed as an extension of AB 3088. You probably saw on the news a lot like, oh, the eviction moratorium extended till June 30th. But the most significant portion of that, in my opinion, was the creation of this state rental assistance program that Gil talked. It's now bumped up to 100%, but you got 80% of the retroactive, 25% of the prospective, plus the utilities. But I will say, I got a lot of calls from a lot of landlords, and I saw a lot of landlords call in at the public hearings on our local ordinance here, complaining that either their tenants wouldn't cooperate with the application, or that it's just kind of in this never-ending processing status and they weren't getting paid. That seems to be getting better. It may have been just kind of a slow initial rollout. I believe they started up in like mid-March or so. But that was definitely a real problem, especially the part where, you got a tenant who just says, hey, I'm not verifying anything. Even if I qualify, I don't care. There really isn't much relief for the landlord. The good thing about AB 832 is it accounts for that, but you'll see there's a lot of other strings, and we'll get into that. So just prior to the expiration of SB 91, so just last month, the legislature gave us AB 832. You've probably heard, oh, the eviction protections are set to expire September 30th. Well, I starred that. That's true in that the 25% program, that's when that's set to end. And of course, it could always be continued again. But you'll see there's these carryover protections that run from October till March 2022. So 2 full years, right, after the onset of these COVID protections started kicking in is when the real end of this is set to expire. And yeah, just as the most significant part of SB 91, I thought, was that rental assistant program, and everyone was kind of focusing on the continued June 30th date. To me, the most significant part of AB 832 is the COVID-19 Rental Housing Recovery Act. And people seem to be really focused on the 100% payments, making landlords whole, and that September 30th end date. And I hear from the landlord bar, again, I work both sides, and there's this sense, or at least from some people, that things will go back to normal on October 1st for your rent cases, and that's just not true. So you have to get your head around that going in. And really what's different this time is one of the big criticisms of SB 91 was, what are you going to do July 1st? Like, you'll have people who didn't qualify, you'll have people who still can't pay their rent. Your goal is to prevent this flood of evictions, but there's no plan for what you're going to do afterwards. So really, what's very different about this one is, assuming they stick with September 30th as the end of that 25% payment eviction protection, is this plan for what they're going to do October through March. All right, so getting into the code now, the first section is 117909, and it gives us some new definitions you'll need to know. Also, there's more definitions in here.
I'm in control. So.
You'll want to go ahead and take a look at those. But I bolded and kind of went over the important ones for the purpose of this presentation. So we now have the COVID-19 recovery period rental debt, which means rental debt or money owed under a tenancy between October 2021, March 31st, 2022. COVID-19 rental debt has the same meaning it's always had, but it's extended now to September 30th, 2021. And then I'm assuming everybody knows, like, you had the protected period in March 2020 to September 2020. And then after that's the transition period. And then now we also have this other new, very important term, is rental debt that accumulated due to COVID-19 hardship. Now that's your COVID-19 rental debt, so everything from before, and COVID-19 recovery period rental debt, or which is everything after October, or a combination of both, as long as it accumulated under a tenancy that was in place before October 1st. All right, so 117910, what are your pay or quit notices going to look like, right, after September 30th? Now, the good thing is the notice can be at least 3 days. So you can be back to 3-day pay or quits, not 15-day pay or quits. But if you're doing a notice that includes COVID-19 rental debt, see, even I get confused, there's so many of these terms, for rent that came due under this program, you still have to do the 15-day notice, right, for that period and follow all those rules under 117903. If it's just October 1st and beyond, you can do a 3-day. If it's a combination of both, I would probably do 2 15 days, quite honestly, because you can't file on one or it'll just get confusing. But you at least have the option, okay? The notices also require the amount of rent demanded and the date each rent payment became due. So your client accountings are going to be absolutely critical. I can already imagine a tenant paying in October saying, well, I'm paying prospectively. I don't care about the COVID-19 recovery period. You know, so what does that landlord do? You apply it retroactive and then only apply 25% to it. It'll get really, really confusing. So I think the best practice is get your client accountings, be very, very clear, you know, what money is applied to what and how you got there, because you don't want to kind of fall into one of these traps. You also have to put the phone number, address for the rental assistance program and this mandatory disclaimer. And also it says if there's one thing wrong with the notice, you can lose not just by like a tenant motion, but the court's own motion. So it's judicial discretion. And we saw that during COVID where people kind of were on these default prove-ups and a judge called, hey, you didn't comply with 1179.035. You're not fitting into this proper hole that you know, and your case is dismissed or they want briefing. So you really need to make sure that your notice is compliant. Probably the most important, arguably very important, is 1179.11. So getting a summons. This is kind of like that emergency judicial counsel rule 1, where the courts won't issue summonses. There's also an element of that in, well, I'll skip that part. But The important part here is, hey, you know, obviously you're going to want a summons. So for the court to issue that on or after October 1st, but before March 31st, 2022, on a case that deals with non-payment of rent that accumulated due to COVID hardship, all of the following apply. So first, full stop. The statutory definitions I showed you a couple slides ago, they don't require a COVID hardship declaration. So understand that you'll have to follow these rules whether or not a declaration is provided based on when the rent became due, because the court is not going to give you a summons. So whether or not the tenant has signed that declaration or not is not dispositive of anything. It's just simply about, well, hey, the rental debt accumulated due to COVID-19 hardship, which is defined as those 2 periods of time. So if it came due in that time, you're stuck with these rules. So if you want a summons, right, obviously you're going to want that. You need to file a declaration with any of the following. So a statement under penalty of perjury that you completed your application for the rental assistance, but it was denied, and a copy of that final decision. So, okay, you applied, the tenant didn't qualify, you got it, here's a copy of it. In theory, the court will give you a summons. 2, a statement under penalty of perjury that all of the following are true. Before filing the complaint, you submitted the application. 20 days have passed since the later of the date you submitted the application or the date you served the tenant with the 3-day notice. So you can imagine a landlord submits the application, it's in this pending status, it's not going anywhere, they're not getting updates, then they serve the tenant a 3-day notice, then they'd have to wait another 20 days on top of that. So you might want to do them both at the same time, just might be a good advice for a client to save on some time there. Next, the landlord has not received or obtained verification from the pertinent government rental assistance program that the tenant has submitted a completed application. So what if they verified that they applied, but they won't tell you if it's approved and you haven't got paid? Well, now you probably can't sign this under penalty of perjury. And then D, the landlord has received no communication from the tenant that the tenant has applied for government assistance. Well, I can't tell you how many times I've seen cases where there's like a text message from a tenant, oh, I applied, you talk to the rental assistance, they kind of say something else, not everyone's not on the same page. So there could be a lot of issues there with signing decks under penalty of perjury. 3, and I bolded this because I think this could be a good option for a lot of people. A statement under penalty of perjury that the rental debt demanded from the defendant in the complaint accumulated under a tenancy that was established after October 1st. So obviously, if you've already got a tenant in place, that's never going to apply to you. But if you're counseling people and it's like, hey, I'm thinking about putting something on the market in September, you might want to wait till October 1st. You'll lose out on a month, but then you don't have to comply with all these rules and subject to yourself to that program if you don't want to. You can if you want to, and also this could always be extended again, but that's just something looking at. I thought, geez, that might be kind of a neat way that you don't have to necessarily be beholden to the program, or if there's processing problems or tenant non-cooperation. This is kind of the rest of that same statute. So they're going to put the declarations on judicial counsel forms. And then the judgment or a default judgment cannot issue unless the court finds upon a review of the pleadings that before the complaint, the plaintiff completed an application to the pertinent government rental assistance program, and the plaintiff's application was denied for one of the qualified reasons. Those were the other definitions in 117009 you'll want to take a look at. You know, that the failure wasn't, that the failure was because of the lack of eligibility, lack of funding, incomplete, something like that. It wasn't because the landlord just said, hey, I don't want to participate in this. In addition, you have to serve the summons and complaint, the copy of the denial notice for the application. If the tenant contests this, you as the landlord have the burden of proof to show compliance. They don't have to prove you didn't comply. It's your burden as the landlord. And And then here, I thought it was interesting, the legislature made this proclamation and declared in the statute the intent that, hey, for rent after October 1st, the landlord has to be paid 100% to prevent a judgment from issuing. For rent before, during the COVID-19 rental debt period, it's only 25%. And then again, it says a summons issued on a complaint based on a tenancy after October 1st is not subject to the requirements of this chapter. So again, that if you're looking at putting something on the market, that might be a good date just to kind of avoid some of these rules. Yeah, I thought Gil did a good job covering this part. 1179.12 is kind of the statutory piece of what Gil was saying about developing the mechanisms to verify the application's been submitted in the court portal. So you'll kind of have this built-in quality control, but obviously you'll want to verify everything with your client. You don't want to go into court saying you've been denied or your client's been denied the rental assistance, and then the judge looks on it on their end and can see that they weren't, or the application was incomplete, or something else is going on. Okay, so this section is also incredibly important, and Gil and I talked before. I agree with him. I think this is in effect now. So this is how a tenant can prevent lease forfeiture in a rental debt case, okay, for any money that came due during this 2-year COVID period. So the 3 things have to apply. The complaint is based on demand for rent accumulated due to COVID hardship. The tenant submits verification to the court that a government rental assistance program has approved the application, and the approved payment from the program, together with any other money the tenant's going to kick in, compensates the landlord 100%. Now, this application, this is the part I have a problem with, may be made at any time before the restoration of possession. So you can imagine, you know, a landlord client has spent the money, gone through the process, gotten the judgment, gotten the writ, you're waiting on the lockout, and now the tenant submits the application for rental assistance that they could have complied with 6 months ago. But it's very clear that they have the right to do that. Even if you now have a judgment, you have that vested property right. Well, the tenant can come in, do this application at the 25th hour, right? And then it's going to stop everything if they get approved, and you will not be able to evict. So upon this application, the court's going to set, you know, it'll be an ex parte application. The court's going to set a hearing in 5 to 10 days. It's going to stay the action, stay the execution of the writ, notify the sheriff. All right. So you're going to be dead in the water on the landlord side, of course. And then at the hearing, the court shall rule in one of the following ways. If the tenant doesn't qualify, then it's denied and the case resumes. If the tenant qualifies and landlord pays, then they're just going to set aside the judgment and dismiss your case. So there goes everything you've been working for. If the tenant qualifies, but the landlord still hasn't been paid, well, it's going to be a continuance. And then at that continued hearing, they have, you know, the steps to follow. Well, if it's approved, if the approval is withdrawn, then it's denied. If the landlord's paid, then dismissed. If they're not paid, but it's not denied, it's continued. And then if the landlord's paid the state portion, but not the tenant, then it's denied. And then the rest of it, you know, of course, there's an attorney's fees provision. So if a tenant does do this and you lose out, well, you're not going to owe attorney's fees as the non-prevailing party. But, you know, what about all of the attorney's fees you just spent to get to where you're at? Like, you're not going to get compensated for that. And then the last 2 sections of the code here for that particular section of AB 832. If you don't have your act together with the summons and the application requirements and everything within 60 days, the court's going to dismiss you. So you're not going to have these OSCs and things getting set out forever. You got 60 days to figure out your paperwork, or they're going to toss you out. And the chapter will remain in effect till September 30th, which to me kind of raised a flag, because we all know the statute of limitations on rental debt is 1 year. So if this program's set to end March 30th, 2022, why do we need this law around for 2 years beyond that? Like, why wouldn't it end March 2023? Because you can only reach back a year under the statute of limitations anyway. And then just some final thoughts. Again, I think the most significant part of AB 832 is this plan of what they're going to do, you know, after that 25% protection ends September 30th. You know, now that they've made this plan and things are funded, the law seems pretty clear. Like, does this mean that it won't be extended again, or the government won't grant another extension? Like I put, for example, here, you know, maybe they extend this 9/30 thing to 12/31 to keep people in their homes through the holidays, or give them that 25% option. Who knows? I mean, I think it's going to depend on a lot of factors. I put some things down here, you know, that really have nothing to do with what we're doing as attorneys. I mentioned before, you know, allowing the lease forfeiture any time before possession's back. They probably should have capped that at the judgment. And again, like I said, I do rep both sides, but on something like that, I see it as very, very prejudicial to an owner's interests after they've made that investment to go through the process. And then the last point I'll make is 117905 is a very important statute. It was in AB 3088, SB 91, but that's what basically protects the state's supremacy, the exclusive province of state law over these COVID-19 rental debt issues. Arguably in San Diego, the only reason they're not banned under our local ordinance is because they can't touch them. But that statute, right, does say the locals still have the authority to regulate just cause. And that was extended till March 31st, 2022. So whether that means that these local restrictions will be continued, again, political factors beyond, I think, a lot of our control, and it's anyone's guess. So anyway, thank you for your time. And I'm going to turn it over to Rachael and Michael.
Thank you. Hopefully you guys can all see the slides. Mr. Olinik and I had to actually separate because our computer was having some technical difficulty. So hopefully you can hear me and you can see my slides. I'm sure somebody will let me know if that's not the case. My name is Rachael Callahan. My company is San Diego Evictions. And just like the two before me, I would like everybody to know that I'm not giving any legal advice. This is just my opinion. Please do not rely on it. Furthermore, I am not creating an attorney-client relationship with any of you. So please just, again, take what I'm saying and what my colleagues are saying as our opinions on this ever-changing world. And so I'm starting mine with a little bit of history. Mr. Mudgett and Mr. Vera did an excellent job, and I'll be going fairly quickly because they did cover a lot of what I was intending to cover as well, just to make sure that we're beating it in to all of you. This again is, like I said, we're going to start with a little bit of a history here. March 19th, 2020 was the executive order, public order directed all Californians to stay home, except for essential jobs. On December 3rd and December 6th, further stay home orders were extended. In short, on March 19th, 2020, there have been some form of stay home orders. Now, I prepared these slides about a week ago. As most people are aware, on June 15th, our economy reopened. However, as Mr. Mudgett just mentioned, we don't know whether or not there will be any further extensions. For example, Nevada State has just issued a statewide mask mandate. There are counties in San Diego, Los Angeles, for example, has reinstated a mask mandate for indoors. And so this is just where we are right now. Assuming all goes well, which I have no reason to assume that, the deadlines that we're about to discuss and that the prior council have discussed will take effect, or like I said, it may be extended. So looking back prior to all of this COVID nonsense, Assembly Bill 2343 established what was required in order to do a pay-quit notice. The pay-quit notice required just 3 days. You simply say you owe this amount of money. You get 3 days to pay it, and if you don't, then we enter into an eviction and we go on our merry way. Again, that was in effect since 2018. The change was that those 3 days then excluded judicial holidays, Saturdays, and Sundays. Prior to AB 2343, it was just 3 calendar days, and again, now it's 3 court days. This became pretty significant once COVID hit because the court actually shut down starting, I believe, March 17th of 2020. And during the time that the court was closed, those days were considered judicial holidays, although not much of a holiday, if you ask me. And so any notices that were prior to that, of course, were delayed in their expiration. Then, of course, I'm just throwing some law out there. I'm not going to read it to you, but the relevant pay rent statute is 1161 subsection 2. Now, this slide is a very, very simple form 3-day notice to pay rent or quit. This is what was required prior to COVID-19 rules and regulations. As you can see, this is a 1-page short document containing information on how much is owed, what time period it is, who do you contact to pay, and basically, like I said, a very short notice, 1 page. On March 17th, as I mentioned, the court closed, and the rules and regulations with regard to how you get a tenant out for non-payment certainly changed. On April 2nd, the Judicial Council, which was statewide, enacted Emergency Rule 1, again deeming the court closure as judicial holidays for the purpose of 1161. On August 13th, the Judicial Council of California voted to end Emergency Rule 1, and of course, then that's when the COVID regulations statewide took effect. On August 31st, Assembly Bill 3088 was signed into law, and this was done again under basically the cover of darkness. We all had anticipated that 2 other statutes may take effect, but lo and behold, Assembly Bill 3088 was the prevailing statute, and this codified the COVID-19 Tenant Relief Act, and it took effect September 2nd of 2020. And so basically, as Emergency Rule 1 ended, Assembly Bill 3088 took effect. At this point, there's no longer a 3-day pay quit option for landlords and owners for rent due from March 1st on. The time period mentioned in AB 3088, of course, was March 1st, 2020 through August 31st, 2020, when we all thought this would be over. Continuing on, at that time, AB 3088, as Mr. Mudgett sort of went into detail on, required certain things to be done in order to prevent eviction. The tenant would return a would return a tenant declaration claiming there was a COVID hardship, and that would be done within 15 days. If the tenant returned that declaration, then the tenant could not ever be evicted for non-payment for rents due March 1st, 2020 through August 31st, 2020. Then, of course, after August 31st, 2020, starting September 1st, 2020 through January 31st, 2021, the tenant would be required to pay the 25% rent to avoid eviction. Of course, AB 3088 was prior to all of these wonderful programs for rental assistance that Mr. Vera mentioned. And so the idea there would just be that we would not be wanting to displace people based on their inability to pay rent due to having a COVID-19 hardship. If the tenant failed to sign the declaration, the landlord could commence eviction, but it would have to be after October 5th of 2020. The new law also required landlords to serve any tenant owing rent for that period of time a written notice, which is still the case, and that has changed over and over again, but that notice needed to be served on or before, I believe, September 30th. So again, more language that I don't need to go into on the particulars, but basically 3 days turned into 15 days. The notice changed significantly. The tenant could return a tenant declaration, of course, by September 30th, 2020, and not be in fear of being evicted for non-payment of rent. Then came SB 91, which took effect, it took effect after AB 3088. I want to say that one took effect, it's been so long. On January 29th, 2021, the SB 91, became effective immediately, and that was 2 days prior to AB 3088 expired. SB 91, of course, extended the protection of qualified tenants and extended the time for tenants to pay the 25% due now by January 31st. That was extended to be due by June 30th of 2021. And again, all that means is that provided the tenant paid 25% of the rent owed after September 1st, 2020, prior to June 30th, 2021, they could not be evicted for non-payment of rent. Again, there were the same requirements under SB or AB 3088 to return the tenant declaration. The notice was now 15 days instead of 3 days. And if a tenant, the idea behind it was if a tenant failed to pay that 25% by June 30th, then you could move forward with an eviction. However, if they paid just that 25%, then you could not. Again, I'll go quickly through this, but there were some slight differences. Mr. Vera discussed the payment option of landlords waiving 20% of the rent in order to get 80%. And if the tenant did not, if the landlord did not agree to the terms, there may be some rights waived. Now, during the tenure of SB 91, we did, just from a practical standpoint, we did have a number of clients complain that that assistance was not coming fast enough. There were difficulties getting tenants to comply, and from what I hear, there were sometimes difficulties getting landlords to comply. However, the idea behind it was, again, if a landlord was willing to waive 20%, there would be some 80%, they'd get 80% of the rent for qualified tenants, and everybody would be happy. Again, under both SB 91 and AB 3088, you were not going to be charging late fees. So again, under the SB 91, there was non-payment portion protections applied from March 1st, 2020 through June 30th, 2021. Rental payments were defined as any rent or other financial obligation of the tenancy. And again, Mr. Vera discussed some of the things that could qualify as other rental obligations. The renters were still entitled to a 15-day notice. And again, like I said, I don't want to spend a lot of time on this because we went through this already, but you were able to ask for some documentation under SB 91 if it was a high income tenant, but for the most part, I'd say as a practical matter, and the other attorneys may disagree, but I don't think so. If a tenant returned a tenant declaration, you were stuck dead in the water, as Mr. Mudgett mentioned, and you would have to wait. The target date at that point was come July 1st, when all of this COVID nonsense would be over with, we would be able to proceed as normal. So remember that slide I showed you earlier? This is the notice to pay rent or quit, how it used to be back in the day, pre-COVID. And then under SB 91, this is what you had. You now had a minimum of a 3-page notice with the amounts. You actually had to specify the date due. You had to include a whole bunch of other stuff informing the tenants of their rights. You had to designate whether or not the tenant was a high income earning tenant, which would have to be something that the owner needed to have proof of. And then of course you had the tenant declaration here, which is the document that the tenant could return to prevent you from evicting them. This covered the rents from March 1st, 2020 through August 31st of 2020. And then there was a second notice that was required, also a 15-day notice for any rents due September 1st, 2020 through June 30th of 2021. This document very confusingly, in my opinion, explained the whole part about if the tenant were to pay that 25% by June 30th of any rents owed September 1st, 2020 through June 30th, then they could not be evicted for non-payment. Again, you'd have to have the date the rent was due, the actual amount specified out, the disclosures regarding the new ways that the tenants could prevent eviction for non-payment. And then of course, again, this tenant declaration where all the tenant had to do was state their name, sign it under penalty of perjury, and they could not be evicted for non-payment of rent. Both of those notices would also need to include this notice from the state of California, another 2-page document. So I think we were up to 6 pages per notice. And this again, informing the tenants of their rights, their right to apply for rental assistance, their deadlines for doing so. And of course, it gave a nice shout out to some of the legal aid and other resources that tenants could use to try to help them through the process. So we're here because AB 832 has now taken effect, effective July 1st of 2021. It was approved on June 28. Interestingly, that's again 2 days right before SB 91 was about to expire. So as Mr. Mudgett mentioned, we're waiting until the 25th hour in order to get these things going. AB 832 extended the protections of qualified tenants and the time for the tenants to pay any rents, the 25% due September 1st, 2020 through June 30th of 2021. That was the prior date. Now they have until September 30th of 2021. As Mr. Vera and Mr. Mudgett mentioned, they are now, owners are now being able to qualify for 100%, even if they agreed to previously waive that 20%. From a practical standpoint, I've had a number of clients this time around say that the funding is coming, the funding's coming quick, and even for clients that waive that 20%, the words that they're using are magic, that the money just magically appears in their accounts, so all is well. Again, AB 832 versus 91. Under 91, the housing assistance was made available for 80% for qualified. Again, AB 832 extends the time period, still covers any rent-related debt. I am having clients mention that they are being paid for utilities, they're being paid for, I've even had some security deposits paid. And again, even ones that have waived that 20%, in order to get the 80% are getting the full amount magically into their accounts. One thing that I will mention is I was surprised to hear from Mr. Vera that tenants who have vacated are able to qualify for the rental assistance. This is a surprise to me only because I've had clients mention that they have been turned away for rental assistance if the tenant is no longer in possession of the property. But it sounds like, as Mr. Vera pointed out, if the tenants and the landlords can work together, there may be some hope there. This, of course, is a huge relief for owners who have gone through for several months, if not over a year, without getting any rent. The 15-day notice requirements under AB 832 are much the same as before. However, it is a new notice that's issued for each time period. The non-payment protections, of course, apply now from March 1st, 2020 through September 30th of 2021, unless that's extended. And again, I mentioned at the beginning, there are some signs that this will be extended further based on mask mandates going back into effect, other states doing that sort of thing. But we'll see how that goes. The Delta variant obviously has a major impact on this as well. Rent payments are still defined as rent or any other financial obligation of a tenant under the tenancy. Renters are still entitled to a 15-day notice, excluding weekends and holidays. And then that's if the landlord seeks rental payments that became due during the covered period. Now that is March 1st, 2020 through September 30th of 2021. So under AB 832, what must be included? It's a new pay quit notice with slightly different language from March 1st, 2020 through August 31st of 2020. Again, you must include that blank tenant declaration. Then there's a new pay quit notice. This one, in my humble opinion, is far easier to understand than the previous one that explains to the tenant that provided they pay that 25% prior to September 30th of 2021, they cannot be evicted for non-payment. The new notice requirement also has information on those programs with the funding for qualified tenants. And then the California notice to tenant is slightly revised, but again, that's required. So I'm taking you back to that slide number 9, where we had this one-page tiny little pay quit notice. I just want to keep reminding you of the good old days. And now this is what we're looking at from March 1st, 2020 through August 31st, 2020. Again, we have a 3-page notice here that has a lot of information for the tenant. You put the date that the rent is due, the ways that they can pay, the way that they can return the tenant declaration. And of course, you now have the tenant declaration. Once again, the declaration under penalty of perjury part has changed slightly. It no longer says that it's under the laws of the state of California. I don't know if that's significant. I just found it to be interesting. And then again, there's going to be a second 15-day notice that covers the period of September 1st through 2020 through September 30th, 2021. Again, you have to put the date that the rent is due, a bunch of information to the tenant about their rights, everything that they can do, and then how they can return that tenant declaration, how they can pay. Now, you may notice at the bottom here of this set of notices, there's this bold, 12-point bold underline statement here. It's hard to read on the slide, but I'll show you on the next one. That statement is now required under the county ordinance, San Diego County specifically, 10724, which I will talk about in a second. We still have the tenant declaration. Again, the penalty of perjury statement has changed slightly. If you have renters, or if your clients or your people have renters that have money owed from March 1st all the way through September 30th, you're now up to 8 pages of notices, plus the California declaration, And again, there's far stricter requirements here. The reason I'm bringing up this little section down here at the bottom of page 3 is just that, as Mr. Olinik will discuss, you need to check your local ordinances, because there may be things beyond what the state of California requires that you need to include in your notices in order to be effective. Again, the notice from the state of California is another 2 pages. So I think we're up to 10 pages of a notice if you have rent due all the way back to March of 2020. So again, this is the statement that you saw on page 3 of my latest notices. This is required on any notice sent to tenants that discusses termination of a tenancy in San Diego County, the entire county, under Ordinance 10724. So again, check with your localities and make sure that you are in compliance with both state and local ordinances. And that's it.
And good afternoon, everyone. I'm Michael Olinik, and I will be delving into issues surrounding commercial evictions. So let me get set up with my, oops. I have a new laptop, so I have to allow access to my screen. Rachael, do you have a copy of mine on yours?
Let me see what I can do, Mr. Olinik. You're asking me, the one who's less technically inclined than you are.
Yes, I have to restart Zoom, so.
Okay.
Oh, I might have it.
Oh, you got it. There you go.
All right. Sorry about the technical difficulties. As my presentation is titled, I will be talking about some issues with commercial eviction moratoriums. Unfortunately, I don't have a lot of answers, which I know a lot of you were hoping for. But because the commercial eviction moratoriums are not a statewide moratorium and instead depend on local ordinances and sometimes multiple local ordinances at both the county and local levels, it's just not as easy as our residential folks had it with being able to interpret a single statute. So like everyone else, I will start out with the disclaimers that nothing I say is meant to be legal advice. And I'm not attempting to form an attorney-client relationship. As we know, the dates may change and even the substance of the ordinance may be amended, especially because we may be dealing with the Delta variant taking control. That Delta variant is more contagious, which is the problem. So hopefully everyone's staying safe, and hopefully, if nothing else, maybe the end of all these strange restrictions would be a reason for other people to maybe get vaccinated. So the key to the commercial eviction moratoriums is to read your local ordinances, try to keep up to date with them so that you're always on top of what's going on. I've seen comments in the questions and answers acknowledging that this can be difficult. Some jurisdictions make it hard to find. For example, San Diego's commercial eviction moratorium was scheduled to end June 30th, 2021, but many people couldn't see whether it actually ended or whether there was any extension to it. So keep digging, keep looking. It took me 2 hours to find the City of Glendale's ordinance the other day. And also do not forget that the local court rules might also vary from jurisdiction to jurisdiction. So it's best to check those too. So we'll start back at the beginning. Unlike the COVID-19 Tenant Protection Act, there is no statewide commercial eviction moratorium. The COVID-19 Tenant Protection Act specifically excludes commercial properties from the definition of a tenant. But local jurisdictions were given the power to issue commercial eviction moratoriums pursuant to Governor Newsom's executive order. That executive order has been amended and has been extended to at least September 30th, 2021, barring any further extensions. On this slide, this is the portion of Governor Newsom's original executive order, and don't bother to read it in full, but as you can see, this was on the commercial side only supposed to be limited to limiting the reason for eviction for non-payment of rent. That's important to note because some local ordinances try to hide the ball on that. And this is some verbiage from the City of Glendale's ordinance. If you read through that, you can see that in no way does it say that this ordinance only applies to non-payment of rent cases. They try to hide the ball there. And a tenant would jump in and argue, hey, this ordinance protects me from any unlawful detainer, not just one based on non-payment of rent. If you read the language, well, Section 2 seems to imply that it's only based on non-payment of rent, but it's not all that clear. So you might end up in an unlawful detainer and arguing about what the local ordinance means and spending money and delaying and litigating that. I'm not here to give you an answer on what the ordinance is. I'm not here to tell you whether an ordinance that goes beyond the executive order's mandate would be legal. I'm just here to raise these issues for you to think about. So the question is how to handle your local ordinances. First, you should look to see if there's any city local ordinance that applies to the property at issue. Then you should look to see whether there are any county ordinances. And then you have to read them carefully and see which ones apply. Most ordinances that I've reviewed do have the provision that if the tenant can provide documentation that say they are suffering from a COVID hardship, they cannot be evicted based on the non-payment of rent. This generally applies to both notices of default, if you want to go that way and terminate the lease under the contract, or actions under 1161-2, which is the traditional 3-day notice to pay rent or quit. Many of these ordinances also give a repayment period that tenants have at the expiration of the moratorium to pay back the debt accrued during the moratorium. I'll talk more about that in a bit, but that is important. Many times you will not be able to go out and file an unlawful detainer on October 1st, if hopefully everything expires September 30th. Because there is a repayment period that the tenants have a right to. And of course, many of the ordinances, just like the residential, say that no landlord can charge late fees or interest. But again, you have to read your local ordinances, whether it's one or two, to figure out which ones apply. So, some of the issues to look out for when comparing the jurisdiction with two ordinances. Sometimes a county ordinance might preempt the local ordinance, and sometimes they both apply. For example, in Los Angeles County, the Los Angeles County ordinance says that it applies to the entire county, including incorporated cities. But if incorporated cities have a local ordinance that offers greater protections, then the local city ordinance applies. That means basically the landlord has to comply with two separate ordinances, which is basically one super ordinance that gives the tenant the benefit of the doubt of the protections of both. There could be an issue sometimes when each ordinance expires. I'll go into Los Angeles as an example again later on the next slide, but some ordinances are set to expire exactly on September 30th, Some ordinances expire in conjunction with the expiration of the executive order, and some have a date certain. It all depends on what the ordinance says. So again, read your local ordinance. Different ordinances might have different periods to repay the unpaid rent. Different ordinances might have different documentations requirements in order for tenants to qualify under the protections. And the different ordinance might also include different exceptions to the ordinance. So to take a look at how the differences might play out practically, let us compare the city and county of Los Angeles. The city of Los Angeles moratorium ends when the mayor declares the end of the local emergency. Again, I am not giving legal advice, and although there seems to be an issue about whether the city of Los Angeles's moratorium can continue even after the end of the governor's executive order, I can't give you an answer on that now, and so we'll just have to see how that plays out. In comparison, the county of Los Angeles's moratorium currently ends September 30th, 2021, in line with the executive orders. Under the city of Los Angeles's moratorium, tenants who did not have to pay rent under the ordinance have 3 months from the end of the emergency to pay their unpaid rent. So at this point, we cannot say what date that is, but they are given a full 3 months with absolute protection to repay that. The county of Los Angeles's moratorium differs. If you have 9 or fewer employees, you get 12 months to repay the rent no matter what. If you have 10 to 100 employees, you have 6 months to repay the rent, but it must be in equal installments. And finally, the exceptions to the two ordinances are different. The city of Los Angeles's moratorium excludes multinational companies, publicly traded companies, or a company that employs more than 500 people. The county's excludes multinational and publicly traded companies, but excludes companies with more than 100 employees, plus commercial tenants of property located at the airport. So the question becomes, what happens if you have 75 employees for a property in the city of Los Angeles? Well, if you have 75 employees, oh, I skipped a slide. I apologize. Let's start with the example. If you have 150 employees, then you do not qualify for protections under the county of Los Angeles's moratoriums. But the city of Los Angeles moratoriums still apply. Therefore, you only have to worry about one moratorium at that point. That makes it a lot easier. The confusion occurs is when you fall under both ordinances, and that's what happens when you have 75 employees. So the LA County ordinance would require repayment of rent within 6 months in equal installments in each month. But the LA City ordinance gives you 3 months for repayment. Now, the county's ordinance says the ordinance with the greatest protection applies. So if a tenant does not pay their equal installment in the first month, they are arguably protected by the LA City ordinance, so that you cannot file an unlawful detainer on the 1/6 of the COVID rent due in the first month. But then if the tenant is protected for the first 3 months under the LA City ordinance, how much does the tenant have to pay on the 4th month? Do they only have to pay that monthly installment, or do they have to pay 1/3 of the full debt, dividing the full debt between the 3 months they have to pay? Or do they have to pay the first 4 installment payments after the 3 months expired? All of that is up in the air, and as we've never had any legal precedents for any of this, we don't know how a court will interpret these statutes. So again, read the local ordinance, but even if you read everything and fully understand everything, there will likely still be legal issues hashed out between landlord sides who will be fighting for one interpretation and tenant sides who will be fighting for a different interpretation. So, as Mr. Mudgett said, accounting will be the key to commercial unlawful detainers in the upcoming months. Normally, this was limited mostly towards residential tenancies, and we knew that was coming because of the different periods set up by statute for the residential tenancies. This is going to become an issue for commercial tenancies, however, as well. So it's important for all landlords and for you landlord attorneys, your clients, to start keeping very accurate and detailed accounting. They should keep track of the full amount of rent owed as of the expiration of the moratorium, which right now we hope stays September 30th, 2021. They should then start a new accounting of all rent that becomes due after the expiration of the moratorium. So basically a clean slate on October 1st, 2021. And now I will explain why this is important. Of course, different jurisdictions, again, will have different repayment requirements and repayment schedules. So please read your local ordinances. Now, most of the ordinances that exist do not explain how you apply payments you receive after the expiration of the moratorium. So right now, we stand in a position where there really is no case law and no general requirements. So this will be an issue that is argued in the courtroom a lot of times. San Francisco's ordinance, however, does tell you how you apply those payments. And for many reasons, the San Diego or San Francisco ordinance is probably a good guideline to follow. This is what the San Francisco ordinance says. And if you notice the highlight section, you can see that all payments should first be applied to rents that come due during the forbearance period, and then to unpaid rents that originally come due during the moratorium period. The forbearance period under the San Francisco ordinance is the time to pay after the moratorium, but during the time the ordinance allows you to make repayments, and then the moratorium period is the period where the rents were not due under the ordinance. So to put in simpler language, San Francisco is saying if you receive a payment in, say, November 2021, you first apply any payment received to the debts owed in that month. Second, you would apply any remaining payment to the debts owed since the expiration of the moratorium. And that would be the forbearance period under the San Francisco ordinance. Then third, you should apply any remaining debts to what was owed from the moratorium period. That is why it's important to keep track of both what was owed before October and, before October, and what is owed after October. And finally, you have to watch out for the 1-year statute of limitations. I'm being told to rush, so I'll just get through this. As we know, California Code Civil Procedure 1161-2, the 3-day notice provision only allows notices to include rent in the past year. Can a lease modify that statute? Right now, the answer is no, although there is a case that says a estimated rent notice under 1161.1 one will not be invalidated as long as it remains a reasonable estimate, just because it includes rent that was due over 1 year. Will there be tolling? I wouldn't count on it. There is a tolling statute, Cal Code Civil Procedure 1179.05C. However, that's from the COVID-19 Tenant Protection Act, and therefore that does not apply to commercial properties. The argument will be, well, at the end of the repayment period, what is the statute? Is it from the start of when that rent was originally owed, or is it from the day the rent was owed under the repayment plan? Landlords will take one position, tenants will take another. So in conclusion, please read your local ordinances, and please start drilling into any clients that accounting will be key. We don't know exactly how the accounting issues will work out in the end. Landlords will want to apply any money they get to the earliest debt, but we don't know if that will fly in the courtroom. So with that, I will conclude my portion, and I think we are opening up to Ashley to handle any questions.
Yeah, so Michael, since there's a question here that pertains to you, and it's whether there is any rent relief for commercial tenants or programs for funds for landlords for tenants who are behind in commercial spaces.
Yes, for that, again, I would suggest checking your local ordinances. I have not personally looked to see whether there is a statewide repayment program, because I haven't gotten that far in my research yet, but I know some local communities have set up some commercial rent relief organizations. So again, I would start out with your local organization and then local cities, and then work your way up.
Thanks. And any of you can answer these questions as I go through them. There were, I know Gil and I and Lawrence were trying to answer some of these in the chat as they were coming up, but one of the recurring ones that we've had was if a lease is expiring by its terms, can the lease be terminated under AB 832? Do any of you want to answer that one?
Sure, I'll jump in first. I think we'll probably say the same thing. It would depend on your local ordinance. So for here in San Diego, we've got the ordinance 10724. So you would not be able to initiate that case at least until August 10th. There's talk it could be continued. We all don't know. But the AB 832, that's really just dealing primarily with your rental cases. So for a just cause reason that's not rent-based, you're definitely going to want to look at your locality. And like I said, for where we're at in San Diego, the answer, at least for the next few weeks, would be not at this time.
Okay, and I think there was some confusion about the 15-day versus the 3-day notice. I know, Lawrence, you were mentioning that you could do a 3-day notice after, I think it was October 1st. So some people were confused about when you have to send the 15-day and when you can send the 3-day.
Right, and it's confusing. So again, go back to those definitions in 117909. If you're talking about COVID-19 recovery period rental debt, so that is money owed after October 1st, but before March 31st, you could use a 3-day. Look at the code 117910. There's other requirements that have to go in that notice. But let's say you're waiting until October or November and you're serving a notice for COVID-19 rental debt or rent that accrued between, like, well, we'll say September 2020 through September 2021, then you would still be subject to all those rules that Rachael went over, and it would be a 15-day. My comment during the presentation is if you had a case that was both, you know, the way that 117910 is drafted, it says not less than 3 days. So if you're doing both, it might be easier just to do 2 15-day notices, because ostensibly you're not going to be filing till the expiration of the other one anyway. So I know it's confusing, but I hope that clears it up a little bit. Look at the definitions and when the rent was due.
Great. And is only one declaration required for the entire covered period, or does the tenant have to provide declarations each month? And what happens if they don't provide the declaration?
So Rachel, do you want to field that one? I think you covered that quite a bit.
Sure. Yeah, the declaration, the owner has the option of issuing a new notice every month. That would be up to the owner to do. And technically the tenant would have a requirement to return a declaration every time a new notice packet is submitted. However, from a practical standpoint and from a practicing standpoint, once we receive that declaration, that's it. We don't continue to expect it because, as Mr. Mudgett mentioned, the tenant has all the way up until essentially the date of possession in order to insert that declaration or insert information regarding the rental assistance applications. And so, again, from a practical and a practicing standpoint, once we get one declaration, that's generally enough for us to pump the brakes on that.
Okay, and then there was a question specifically for you, Rachel. So when you were talking about the local language for San Diego that was on your 15-day notice, where is that required? The person was saying they haven't seen it under 117903. Right, and the question I think was from Pamela, and it was a great question. And she asked specifically if we include that just in case, since 1161.3 doesn't specifically require it. The short answer is yes, we're including it because in San Diego, the San Diego Ordinance 10724 does in fact require that. And so in order to avoid running afoul of that local ordinance, even though the state statute says you don't have to include that on there, it's kind of like a no harm, no foul. And if we're right and it's not on there, then the foul is you don't get to prosecute your case and you may have spent a bunch of money on attorney's fees. And so I included it because that's what our local ordinance says to do, even though the state law doesn't specifically require it. Let's see what else we have here. So there was a question about whether these counties have the power to prohibit evictions other than non-payment of rent based on Newsome's order. Well, in San Diego, they seem to be able to do it. We're not doing any evictions right now. The one exception that the San Diego County Ordinance allows for is if the tenants are committing an imminent threat to public health and safety at the property affecting other tenants. Essentially, there are no real exceptions to the local ordinance. There have been challenges to it. And so the short answer is, again, yes, the localities can do that because so far all of the challenges to that type of ordinance, at least what we've seen in San Diego County, have failed. Now, from my heart's opinion of it, do I think it's constitutional? No. Do I think that there should be conflicting local and state and federal rules? No. But so far, County of San Diego has upheld that ordinance.
And on that question from the commercial perspective, again, check your local ordinances. Most commercial local ordinances only affect non-payment of rent, and that would be in line with what the executive order says. But just check your ordinance to make sure. There's also the issue about whether you can terminate a month to month when the tenant has said that I have a COVID hardship. And there's nothing that prevents you from doing it, but you will be running into some litigation issues with claims of retaliation, and that will happen no matter whether it's residential or commercial.
I think I would also add on, sorry, to Rachel's response, just statutorily, take a look at 117903, if I'm remembering correctly, or is it? Sorry, 117905, I apologize. That's the one that carves out and says basically the states, the localities do have the authority to do the just cause. And if you're looking at the just cause statute, 1946.2G is what gives them further authority to do that. Our local ordinance here draws from that very heavily. So again, you know, whether it was reasonable, whether it went too far, whatever, it's constitutional, completely different discussion. But if you're looking for statutory authority for that, it would be those two codes.
I know a lot of these questions are really difficult to even answer because they're not giving any, you know, city or county of where the property is located. They're all just generalized questions about what happens when, you know, an owner wants to sell and so forth. And again, I think we'll reiterate that that has to be based on local ordinances and what those allow.
Actually, I would actually comment on that as well. One thing that people should keep in mind is whether or not it has a good optics. I mean, do you really want to be, in general, kicking people out even if you can right now? And so that's something that I know that other attorneys have also pressed upon with their clients when talking about it, is even if it is allowed, should you do it? That may not be covered by the law, but that is something to consider.
And have you heard about any extension of the San Diego County ordinance, any of you, that's supposed to expire on August 15th?
I haven't heard anything either way.
Let's hope not.
Ashley, we would have liked to have received an order in the federal court, essentially either establishing that end date or picking another end date, which did not happen, unfortunately. And so, although I personally haven't heard anything affirmative to say that it's going to be extended, I also don't know that August 15th is the date that it expires. That has been a date that's been thrown around. August 10th has also been thrown around, and these have all been in the county briefing in the federal court. But we don't know that it's going to expire on August 14th, and I highly doubt it. I don't see local San Diego County ordinance expiring prior to the California state moratorium.
Great. Okay, well, I know we're out of time, so please feel free to email our panelists if you have questions that you need to follow up on with them. This seminar was recorded and will be emailed to everyone post closing here, and you'll get a copy of the slides for the PowerPoint as well. So thank you all to our speakers for being here, and we appreciate all the information provided.
Thank you, Ashley.
Thank you.
Thank you, Ashley. Bye, everyone.